why would Williams Refrigeration and Heating Incorporated make these statements? Are they wrong?
Were they there? They were not there.
Well, they were there on January 18th and January 25th.
He says that we bent some valve, and he's stating that.
He's saying it's your fault.
Yeah, I understand.
Yeah, but I mean, Williams Refrigeration and Heating Incorporated did some things, some work here.
Yeah, and the thing was leaking prior to that.
But you fixed it, didn't you?
I fixed one valve, and then there was another one. I said, you're going to have to get a heating and cooling guy.
What about the tile? I've got pictures of the tile here where Mr. Elliott says...
Could I come up and...
You want to look? Go ahead. What about all that?
This is where they walked on the tile floor before it was cured. We did the floor in sections, okay? We did the first section so he could continue walking through and use his kitchen because his stove and refrigerator had to stay connected during this remodel. That was another thing that was on him. So this refrigerator was pushed back and forth on the tiles before they were cured and grouted, causing them to come loose. And there was about 15 tiles, not 60. And I did tell him a couple tiles. But it wasn't on me.
What do you mean it wasn't on you?
He walked on the tiles before they were cured, or...
Then, is that true?
No, sir. Sir, he put the tape on the tiles so he could tell me which tiles he did that day, and we would not walk on those tiles. He just asked you why the tape was down there. He's the one that put the tape down.
You never helped in this endeavor
Sir, I
at
never
all?
did a thing other than pick up the material.
Is that
I
true?
have a torn rotator cuff.
I know that.
And I have a
Yes,
heart
he
condition. I
did
can't
help
do
on
none
it.
of this.
His nephew helped, that lives 2 doors away.
All right.
Sir, I didn't install anything.
Well,
I'm
no, you
not-
have a
I'm not
torn
a
rotator
carpenter.
cuff. You can't. You're
That's
hurt.
correct.
You're on the disabled list. You
That's
can't be
correct.
installing things.
Big problem here, no written contract. What is the judge going to do? The judge is going to have to look for inconsistencies and whatever proofs exist. Plaintiff has the burden here. This is a close case. I would say a slight edge, and I mean slight edge, to the plaintiff. But let's see what the judge says.
You know, I've been on the bench 12 years, and if there's anything that I've learned in 12 years is that and it's similar to the other case, you've got to get things in writing to establish an agreement when you're going to have work done or have some sort of business relationship. And that's what you had here, was a business relationship. There was some sort of agreement between the two of you whereby you, Mr. Dexter, were going to do something in terms of remodeling this kitchen for money. Now, what the exact agreement was, I don't know, because you don't have anything in writing. And you two have different stories as to what the agreement is between the two of you. You know, one agreement is that, or one part of the story is that Mr. Elliott was going to help. Mr. Elliott says no, he wasn't going to help at all. He wasn't going to lift a finger. In fact, he couldn't do it. And so, again, I have to try and figure it out what the two of you agreed to if I'm going to find out whether or not anybody's entitled to anything. And it's hard to do when you don't have anything in writing. Get it in writing next time so you don't have this sort of problem. The other thing, Mr. Elliott, that you need to understand is if you want to have work done on your house and you want to have it done by someone who is maybe not necessarily a friend but somebody you know, and it's not through an established company, you run the risk of this type of problem happening. If you would have picked up the Yellow Pages and called some established company, I don't know which one, there's a million of them in the Yellow Pages, and most of them are bonded, they're licensed. You can check them out at the Better Business Bureau. They're established companies. They've been around a long time. If you go and you hire these people to come out and do the work, I don't want to say you're always going to be guaranteed of having a good job done, but you stand a much better chance of getting a good job done when you go and you hire somebody who you don't know, who maybe did good work for somebody else, but isn't established in the community as doing this type of work. Maybe you pay a little bit less, but you run the risk. It's like buying a used car. You know, you go to Fast Eddie down the lot and pay $300 for a used car, who knows what you're going to get? You go to a dealership and buy a brand new car, you're going to pay a lot more money, but you're going to be protected. So, you know, some of this is, I don't necessarily say your fault, but a result of you trying to get things done outside of the normal way, trying to save a buck here and there. Let's try and break this down as much as we can here, because I've got to make a decision, and I need to base it on some sort of legal principle. And let's start with the furnace, the boiler, which I think is the strongest part of your case. You said that Mr. Dexter installed a valve on the boiler, and you admitted that you did that.
Yes, I did. With his help. He relit the boiler. He was there.
Well, you know, maybe he did, maybe he didn't. We don't know what he did and what he didn't do because we have a dispute. You say he helped you, he says he's injured and can't do it.
I wasn't even there, sir.
He wasn't even there. Who knows?
I was at work.
At work. Who knows? I don't know whether he did it or not. I can't tell between the two of you. You know, I might as well flip a nickel on that. There's no way that I know. What I do know is that you did install a valve. And apparently there was no problem with this boiler before that valve was installed.
Yes, there was. That's why we replaced it. It was leaking.
Was it leaking?
No, sir.
Why was it? It was. You said he had to fix it because he damaged it.
He was installing the tile around the furnace.
That's your opinion.
And he bent 3 other valves.
I find that it's more likely than not that the boiler was functioning properly before the valve had to be replaced. There's nothing to indicate in this agreement, if you can call it that the two of you had, that work was going to be done on the boiler. It's reasonable to assume that the boiler, therefore, was working properly. We know you replaced the valve. We also know that right at that time, Williams Refrigeration and Heating Incorporated had to be called out to do work on it. And there was about $1,000 that was paid to Williams Refrigeration and Heating Incorporated for some work that was done. And coincidentally, it was done right after that valve was replaced. So I think it's more likely than not that the work that Williams Refrigeration and Heating had to do was as a result of the valve that was put in that boiler, and as a result of that valve being put in defectively. Obviously, I can't prove it. I wasn't there. But I think, as I said, it's more likely than not that in small claims cases, all you have to do is prove the case by what we call a preponderance of the evidence, which means if it's more likely than not, then you have proven the case. And that's what I think we have here. So I think, Mr. Dexter, that you're liable to pay Mr. Elliott for the cost of replacing that boiler or having the work done on the boiler. I don't think it was ever replaced. And that comes out to $1,008.22. Now, there's some other things here as well. Let's look at the tile. I've got a bunch of pictures showing that the tile was installed improperly. And some of these pictures are better than others. It's hard to really show the court how tile was installed by way of pictures. You really have to be there to look at it, but arguably some of these pictures show that there was some problem with the tile work. There's no way, really, for me to tell whose fault that was. There's a dispute in the testimony as to who did the work. You say you weren't there, you didn't do the work, you say he was there to do it. I can't tell who it was. So, you haven't proven the case, I guess is what I'm saying with respect to the tile, because there just isn't enough convincing evidence to say that it was his fault. I don't know whose fault it was. I don't know even who installed the tile or not. This is what happens when you don't have something written between the two of you. It's just impossible for me to figure out. Keys. You gave Mr. Dexter keys to the property, right?
He took the key for the property. He locked himself out of the house, called me up one day, said, I locked myself out, how can I get in the house? I told him the code to the garage, so he opened the garage, took the key, and did not put the key back. The last day he was there.
He took the key back.
Pardon?
You gave him the code. He locked himself out of the house. You gave him the code. He got in the house.
Correct.
And then how did he get the key?
He took the key out of the garage. The key was in a key lock in the garage under a table saw that I have in the garage.
Okay.
He took the key. When I asked him for the key back, he said he didn't have the key.
Well, why did you give him the code to get into the house?
Well, he was there doing work. We weren't home.
Well, you know.
He did work for my daughter and son-in-law.
How did you get the keys?
I never had no key. His wife let me in, or he let me in every morning.
You never had any keys?
No.
And you saying he did have a key?
Sir, we leave for work.
Wait a minute. How do you know he got a key?
He called me on the phone and says, I'm locked out of the house, how can I get in?
Right, you gave him the
I told him, I
code.
said, John, the code for the garage is this, this, and this. The key is under the saw in the garage. He went and got the key and opened the house and worked in there.
After he opened up the garage door.
Correct.
How did you get in the garage door? I
Just
mean,
like
in
you
the,
just
I mean,
said,
the
I went
house.
in that garage with the key,
You what?
opened the garage door by the code, went
Right.
and got the key and put the key back.
And you say
Just
he
like you
kept the
told
key.
me to.
He kept the key,
Well,
sir.
I have no way of knowing who kept the key or who didn't keep the key. I'm not gonna award any damages based upon that. Who knows? What else do we have here? We've got the washer and dryer. Again, there's no way for me to figure out what the deal is with respect to with respect to that. The testimony conflicts. You know, if you had that type of deal, you've got to do a better job documenting it, Mr. Elliott, because there's no way for me to figure it out, like I said here in court. I don't know what happened to the garage door. I mean, to the washer and dryer in this case. So I'm not going to award any damages with respect to that. We have your tools that you indicate were essentially stolen by Mr. Dexter. A police report was filed. The police apparently are not pursuing it. Is that correct?
Sir, the reason they're not pursuing it is because my daughter, when Mr. Dexter had told my daughter about the washer and dryer deal, my daughter said, Dad, I want to stay out of all your dealings with John. Says, I'm not going to have him do any more work in my house. Whatever you do with him, we'll let you deal with it. I said, no problem. After that is when John and I made the deal on installing the garage entry door for the washer and dryer. So my daughter had no knowledge of this. When the
But
detective,
what does your daughter have to do with him taking the tools?
no, you were asking about the washer and dryer.
I'm done with that now, the
Okay.
tools. He filed a police report or the police are not pursuing the.
Right, well, the police
the tools.
were
You know
involved
why?
in the washer and dryer and the tools.
Oh,
They said
both.
if I did not see him take them, that there is nothing they could do about them.
Well, I'm going to adopt that position too. I mean, I don't know where those tools are, you know,
He never had any.
who knows? Who knows? I can't tell based upon the testimony provided here today, so I'm not going to award any damages based upon that. The only thing is that you're entitled to, I think, Mr. Elliott, is to be compensated for what you paid to have the boiler work done. That's $1,008.22. I'll award a judgment in that amount. I'm going to add costs consisting of a $65 filing fee and a $27 service fee. That's a total of $92. That'll be $1,100.22, I believe. $1,100.22 after court costs are added. That's the amount of the judgment.
So a split decision. The plaintiff won what he could prove and lost what he couldn't. Bottom line, get a written contract. If you find that you are involved in a dispute that you can't resolve, small claims court may be the answer. Thanks for watching. Case closed. I'm Charlie Langdon.